Okay, this morning I want to do three things. First, I want to finish, and it won't take too long, the discussion of the federal judiciary. Second, I want to just take a moment to see if there are any questions about governmental institutions, and then keep in mind we're going to be transitioning again to the final section of the course that deals with policy, public policy, and policy outcomes of the federal government and its institutions and processes. So before we do that, we'll see if there are any questions about overall about governmental institutions. Your paper on the your paper assignment on presidential power and Guantanamo is in part a paper that deals with the power of governmental actors and institutions. So that's what we're going to do this morning. Are there any questions before we start? Okay. Well, I want to talk about two variables or two themes that often are employed in looking at the federal courts. And one theme, and I should say that often these themes or concepts are not always used in the most appropriate way. One theme is judicial activism and judicial restraint. And this concept concerns essentially the style of a judge's behavior with respect to the other branches and the states. And in part, and I think we may have mentioned this in an earlier class, because the Senate has the role of advice and consent, it's often the case that justices that are nominated by the president claim to be very restrained and modest in their conception of the power of the federal judiciary. Anybody who believes that, I would like to sell them the Brooklyn Bridge at a reduced rate. One can't tell whether those kinds of claims and assertions in the confirmation process have any relationship to reality. So one set of concepts, though, is judicial activism and judicial restraint. And we'll talk more about that in a minute. Excuse me. And the second set of concepts that are often employed is strict construction versus a broader construction of the Constitution. Those who argue for a strict construction basically say that the framers' intent needs to be determined by the very words, the specific words of the Constitution. Those who argue for a broader construction of the Constitution say that that it's important to determine the content and purpose of the language in the document. So the context, again, for the federal courts is that we now are at a situation where there's a roughly equal partisan division between judges appointed by Republicans and judges appointed by Democratic presidents. And this has occurred after 3 decades in which most of the judges on the federal bench were appointed by Republican presidents. One of the implications of that is that the rhetoric that you often hear on television about liberal judges is just so much baloney, because through most of your lifetime, almost all of your lifetime, the majority of of federal judges have been appointed by conservative Republican presidents. So what I want to argue is that liberal, more quote-unquote more liberal and quote-unquote more conservative judges are both activist and restrained, but in different ways. Liberal judges tend to be more activist when it comes to using the power of government to protect individuals and the common good against businesses and individual property owners and corporations. They're more restrained when it comes to the use of government power to promote order, more order at the expense of civil rights and civil liberties. They're also more activist in supporting the rights of citizens to have access to the courts in order to protect individual rights and the public welfare. Conservative jurists, on the other hand, tend to be inclined to support and defend, and more activist in defending the police power to maintain order. They tend to be restrained when government seeks to regulate businesses and private property owners, and tends to be not particularly positively oriented to, tends to be more activist in restricting citizens' access to the courts. The Lilly Ledbetter case is a good example of just that kind of conservative activism. So liberal judicial philosophy tends to be associated with these 3 points. First, a defense and expansion of the equal rights of individuals, and the defense of those rights and liberties against governmental power. Secondly, a defense of governmental actions to regulate business and economic activity, especially when it protects civil rights and civil liberties of Americans. And thirdly, to provide, it tends to be committed to greater and easier citizen access to the federal courts. So in the case of the Lilly Ledbetter case, the more liberal justices were inclined to support her claims. Those more conservative were not. A conservative judicial philosophy tends to be committed to the police power of government to maintain order, even when it may cost individuals, may infringe on individual rights and civil liberties. A good example of this is the conservative judicial response to the Miranda ruling, which was to continually narrow it over the course of several decades. Secondly, a conservative judicial philosophy tends to be committed to the defense of the property rights of businesses and individuals, even at the expense of solving social problems or protecting equal rights and civil liberties. And again, to repeat, it tends to be oriented toward greater limitations on citizens' access to the courts as a way to protect civil rights and liberties or to redress harms or injustices. Again, the Lilly Ledbetter case being a good example. Well, the conservative turn of the Supreme Court has been noticeable for about 20 years now. It began with the Rehnquist Court, which was often closely divided, and has continued with the Roberts Court. 2 of the better-known conservative decisions were the Citizens United case, which has allowed virtually unlimited amounts of money to be contributed in political campaigns by those who have the money, even if it drowns out the voices of those who just vote but don't have money to contribute. And the McDonald v. Chicago case, which invalidated a local ordinance with respect to the regulation of guns. We talked last time about rulings overturning precedent by the Supreme Court, and here you can see a chart that indicates especially the tendency of the court in the last 20, 30 years or so to the Rehnquist and Roberts courts to overturn precedents with conservative rulings. And again, this is an example of the judicial activism of the conservatives on the Supreme Court, whereas the number of precedents overturned by the Warren Court, for example, or the Vinson Court some years ago, some decades ago, was much reduced. And here you can see also the significant increase in the percentage of federal laws found unconstitutional by the Rehnquist and Roberts Court. So this is an example of a court that has dramatically increased the number of decisions which find laws passed by the Congress and signed by the President to be unconstitutional. So what we see is a much more activist court in the past, Supreme Court in the past 30 years, with respect to its tendency to find laws passed by Congress unconstitutional. One other aspect of and troubling aspect of the federal courts in the aftermath of 9/11 should be noted, and that is there's been an increase in the importance in courts which are really not visible and accountable. There's a Foreign Intelligence Surveillance Act court. It's called the FISA court. And while its members are appointed by the Chief Justice, basically what goes on there is not transparent to the American people. It's where people who are alleged to be terrorists of one kind or another are tried by a court, but that whole process is really very difficult to get any kind of information on. Similarly, the Alien Removal Court is also much less transparent than other courts in the federal system. And the treatment of enemy combatants, or so-called enemy combatants, has been a matter that has largely escaped scrutiny. There's been some legislation, there's been some lawsuits. These enemy combatants or alleged enemy combatants have been detained for many, many years at Guantanamo without being charged. Some subsequently have been released without any charges ever being filed. There are reasons for that I won't go into. The Bagram Air Base detainees, there may be 600 or 700 detainees in an air base in Afghanistan. These detainees, of course, came after 9/11. They've not been accorded prisoner of war status by the United States, and so basically their rights under international law are not protected. And finally, there's been a U.S. policy. I don't know that it's still continuing, but it did exist under the Bush administration, of rendition. Basically, what rendition is American forces or CIA personnel capture and detain a person who they believe to be a terrorist or a threat to the United States, and without any trial or any legal process whatsoever, transfer that person to a government that will take that person and imprison them without any trial or any essentially legal rights. President Obama has pushed somewhat for improved, if limited, visibility and greater fairness for some of these people, because many of them have been detained for a decade or close to a decade, but have never been charged with any particular offense, nor have they been accorded rights under international law. And so those are some troubling aspects of the federal courts after 9/11. Keep in mind that this is a really significant use of the police power of the federal government to be able to detain people, not try them, just detain them indefinitely without any charges without any really recourse for these people. Many of them, in fact, may be terrorists. Some of them clearly have not been, because the federal government under Presidents Bush and Obama have released some of them. So, stepping back to the routine, the normal way that the federal courts operate, what are the checks and balances for the federal courts? Well, one set of checks on the courts is judicial traditions and doctrines. Excuse me. The doctrine of self-restraint, the fact that the federal courts have a relatively narrow case-by-case focus and that they have limited remedies available to them. The doctrine of stare decisis, or the respect for precedent, prior rulings by the federal courts and by the Supreme Court. The fact that the Supreme Court will only hear justiciable disputes, so that if somebody has a policy difference or disagrees with the president or some political official, just because you disagree doesn't mean that you can sue. There has to be a justiciable dispute and some disadvantage or harm or injury that the plaintiff has experienced, or at least claims to experience. We haven't talked about it, but I don't think, but the courts will not consider what it deems to be hypothetical or political questions. When very, very controversial issues are brought to the Supreme Court, that one of the traditions of the court is to simply say, hey, look, this is really something that can be worked out by the legislative branch and or the executive branch, and we're not going to get involved. An example of that was when lawsuits were brought during the Vietnam War, saying that the Vietnam War was unconstitutional. The court's position was, hey, we're not going to get involved in this. If you're opposed to the war in Congress, well, stop funding it, and that'll take care of that. So leave us alone, we're not involved. And finally, the fact that the federal courts have few, if any, enforcement powers compared to other bodies. They don't have their own police force that they can send out to implement decisions that they make. A second group of checks on the federal courts is other governmental bodies. Congress creates federal courts. Federal courts only exist because Congress has created them. They create the courts, they create their size, they create their jurisdiction. They can change it. They can make new courts. They can eliminate existing courts. The impact of lower courts and lower court rulings can be a check on the Supreme Court and on the federal courts generally. The Senate power to advise and consent. The only way somebody gets on the federal bench to begin with is if they're confirmed by the Senate of the United States. So if the Senate doesn't want to put anybody on the federal bench, it can just vote against every presidential nomination. The Congress also can pass new laws, as it did in the case of the Lilly Ledbetter Act, which was designed to overturn a previous Supreme Court decision. And of course, Congress can initiate the process of constitutional amendment. Another check is that the President and the executive branch, usually the Justice Department, vet candidates. Not anybody can just walk in and be a federal court judge. And so there's a vetting process in the executive branch, just as there's an advice and consent process in the U.S. Senate. And finally, state and local government bodies can, because we have a federal system, can make decisions and do make decisions routinely which appear to violate Supreme Court rulings. And then it's up to somebody who is aggrieved, who's damaged, who's harmed, to use the political process or the legal process to stop that from happening. And finally, a third check is public opinion and local and community traditions and practices. It is true that federal judges serve, assuming good behavior, for life. It is true that they are not elected. It is true that they never have to run for office. It is true, therefore, that they never stand before the people, at least federal judges. Many state and local judges do have to run for office, but federal judges do not. That doesn't mean that they can afford to be contemptuous of the American people and public opinion, because over time, if in fact courts and justices are, one would expect that the legitimacy of the court system itself would be called into question, and obviously that would be a very destabilizing force in American government. All people in politics, or most people in politics certainly, including judges, want the history books to be relatively kind to them. And so they do need to pay some attention to public opinion as they make their rulings and as they conduct themselves. Okay. This is all I have to present with respect to the federal judiciary, and this really concludes the section of the course that deals with governmental institutions, national governmental institutions. Before we move on, I'd like to ask you if there are any comments or questions about what we've done in this section of the course. Anybody have any comment?
Nothing here.
Okay. I'm going to load this next PowerPoint. Again, keep in mind the image from one of the initial lectures about the American political system and how we're now talking about the final section of the course, which deals with public policy. Public policy, well, we'll wait till the PowerPoint comes up, but and then we'll proceed. Our first discussion of public policy will focus almost exclusively on domestic policy. That is, policies that concern people of the United States internally and not foreign policy. So we're going to look at domestic policy and with some emphasis on economic policy. So when people think about public policy and governments making public policy, they often assume or suggest that there is a policy process that is rational, that is a step-by-step linear process to address public concerns and societal needs. Let me try to explain what I mean just by using, your own situation. So let's say Christmas is coming up, and you really need to buy some presents for people in your family, let's say your parents. You have no money. So the problem you face is, I need to get my parents a present for Christmas. That's a goal, okay? But you don't have any money, and you think stealing is really not a good idea or option, which would be very smart. So a present usually costs some money. So you've identified the problem. The problem is you don't have any money, and you want to get your parents a Christmas present. And that really then becomes your main focus for the next 3 weeks. So you need to formulate a solution. So what's the solution? So there are a number of possibilities. You could borrow it from somebody. You could tell your parents you're going to do more work around the house and they should increase your allowance. You could get a part-time job on the weekend, maybe 3-4 hours, half day, making minimum wage. That, you know, if you made $7.50 an hour, work 4 hours a weekend, that's $30 less whatever is taken out. Do that for 3 weekends, you'd have a little bit of money. You'd certainly be able to buy your parents a Christmas present. So let's say you select the solution of a part-time job. So then you go to the job and you get paid. And as a result, you have money, and you then go shopping and give your parents a Christmas present. And you've solved the problem, you've given a present, and you've done it in a step-by-step way. You rejected some alternatives, you chose one, and you implemented it, and then you achieved your goal by buying that present. So what we've just gone through is a kind of rational step-by-step process of problem solving or policy making. You could have said, well, the problem is not that I need to get my parents a Christmas present. The problem is I need to party with my friends, and that costs some money. I need to get some new clothes. And if you had thought that instead, you would be saying, oh, I've got a different goal, policy goal, all right? And maybe in a 4-hour a weekend job, I'm not going to make enough money to achieve both those goals. Which one is more important? One knocks out the other, and you do whichever policy you want to do. So that's a rational model of the policy process. Only, of course, we're going to apply it not in your own life, but in the sense of American government. So, excuse me. So some of the policy-making steps are agenda building, determining what we're going to do, what the issue is, formulating a policy, looking through various alternatives and deciding what it's going to be, adopting a policy, implementing the policy, and then evaluating the policy. You know, in the case of the Christmas gift for your present, is it something, once they open it and they look at it, is it something they like? Or is it something, hey, I already got 3 of these, what do I want another one for? That is an example of a policy evaluation. Well, you made a great choice, you made a lousy choice. The difficulty is that while this may make sense in thinking about your own life, it really doesn't make a lot of sense in looking at public policy, because public policy normally doesn't work this way. Deborah Stone who is one of the premier political scientists dealing with public policy, says this rational model fails to capture what she sees as the essence of policy making in political communities, which is people struggle over ideas. People struggle over political and policy ideas. Also, this model is a model. It's really not empirical. It doesn't actually describe how public policy processes really work. The example that we gave of your needing to buy a Christmas present is a very simple kind of activity in an individual life, but as you can imagine, the political process is a lot more complicated. And sometimes, and these are really my favorites in the policy process, and I'm putting favorites in quotes, there's some people who don't worry about problems. What they want is a particular policy or program to be adopted. They start with the supposition that X needs to be done by some governmental entity. That's what they start with. They don't need any evidence. They don't need to look at data. They don't need to look at what the community's needs are, or the state's needs, or people's needs, or anything like that. But this should be done. Once they figure out what their policy priority is, then they look for a problem that it can solve. This is doing things ass backwards. All right? I want to do something, and therefore in order to sell that idea, I need to find a problem that it will fix, or something that will improve. This is the furthest thing from rational. So what are we talking about when we talk about public policy? I'm giving you two definitions here. One is a simple one. First one is a simpler one. The second, more complex. Public policy can be defined as official and unofficial government actions, programs, services, taxes, spending that address one or more public issues. Even more simply, public policy is what governments do, but it's also what governments choose not to do. A more complicated definition is that public policy is a purpose of course of action or inaction that's produced as a response to a perceived problem of a constituency, some organization or group of people or states or communities, and or one or more parts of the country, formulated by a specific political process and adopted and implemented by a public agency or its designee. All that fancy language at the end means that some either legislative or executive actor has to approve it, and or executive actor has to approve it and then implement it. Bottom line, public policy is what governments choose to do and choose not to do. You might be confused by the choose not to do. Let me give you an example. Some years ago, there was a book written by a well-known political scientist named Matthew Crenson. And he did a study of Gary, Indiana. Wrote a whole book on Gary, Indiana, and the politics of Gary, Indiana. This book is probably 40, 50 years old. And it started a whole series of a great amount of research dealing with this approach to public policy. The question he asked is, why is it that Gary, Indiana has horrible environmental problems, environmental pollution? He's writing, again, 50 years ago. Nobody does anything about it. The local government, state government, nobody does anything about it. frankly, it's a pretty easy question to answer. Most of the pollution was a consequence of the operation of U.S. Steel plants. And most of the economy of Gary, Indiana, much of the employment, was at those very same steel plants. So if the city government began to act in a strenuous way to deal with problems of environmental pollution caused by the steel plants, they would probably leave, number one. And number two, they probably wouldn't have dealt with those environmental problems in any case because of the perceived and real power of the steel industry in the city. And so the city did nothing. That was a policy decision, or non-decision, if you will. And so that led to any number of studies that looked at agenda setting in politics and public policy making and why problems never become considered by governmental bodies. The literature on public policy. Let me step back. We might define domestic policy as all laws, government programs, plans, actions that concern internal issues of national importance. That's what we're talking about in this presentation. And the literature on public policy identifies three different kinds of public policies. Regulatory policy, I'm going to talk about each of these. Regulatory policy, promotional or distributive policy, and redistributive policy. In each of these policy types tends to be associated with a different kind of politics, which we'll talk about. So examples of public policy might be acts of Congress, executive orders issued by a president, and court decisions that are implemented. So while there are issues with the regulatory and the redistributive and distributive policy categories, and we'll get into some of those, it's important to keep those in mind nonetheless. So first, distributive policy. Distributive policy tends to be associated with interest group politics and tends to be less transparent than other forms of the policy process. This kind of policy making is related directly to the discussion we had much earlier in the course about interest groups and the work of E.E. Schachtschneider that we spent some time on. So distributive policy can be defined as a government effort to distribute a good, a service, or targeted benefit to some portion of the population or some entity in the country, often in an effort aimed at solving public problems. Sometimes we might call these earmarks. Sometimes we might call them subsidies, as we'll see in a minute. So distributive policies are among the most common forms of federal action and are typically paid for through our tax dollars. As such, these kinds of policies provide everything from farm subsidies and corporate contracts to infrastructure and pork barrel spending, special spending often for projects that are favored by congressmen and senators. So one form of subsidy, one form of distributive policy is the subsidy. The subsidy is where the federal government gives a company or companies cash or other valuable commodities. Energy and pharmaceutical companies have been some of the recent beneficiaries of federal economic policy and subsidies. Government also awards contracts, and it gives subsidies to farmers, dairy farmers, other kinds of farmers, to do certain kinds of things with their fields and their crops. In the case of energy companies and contracts, sometimes these opportunities offer firms an incentive to overcharge the federal government for its services. So subsidies or distributive policy seems to be less controversial than many other kinds of policies. It basically is a situation when governments say such and such a business, such and such an economic sector, such and such a corporation, such and such a group of people, we're going to help you and give you some money for any number of reasons. An example of a distributive policy could be considered to be aid to areas and local governments where there's a disaster. A tornado blew through your town. Your town is devastated. It's leveled. You have to rebuild. Federal government has programs to help towns and communities like that. Okay? It's already in the budget. There's a certain category of constituency, devastated towns, we're going to help you. Here's money. Regulatory policies are enacted by Congress and implemented by federal agencies that develop formal rules, usually with respect to specific and large groups of people or industry. The federal agency enforce or implement those laws, and they set up rules which are designed to enforce the laws, and sometimes penalties as well, enforce the laws that Congress has passed. A regulatory policy provides a framework that allows agencies to develop rules. They develop guidelines for promulgating, implementing, and enforcing whatever public protections are in the law passed by the Congress. And often these are these regulatory policies affect one specific industry, and this fits nicely in with our analysis of subgovernments earlier in a few lectures ago. I'm going to do one. I think I'm going to stop here because redistributive policy is complicated, and we'll pick it up next time with redistribution. So we'll see you next time, and keep in mind your papers are going to be due pretty soon. Bye-bye.
Have a good day.